The most important thing for drafting is that you have to split up the writing process. So the research process is different from formulating your arguments, is different from writing a first draft, is different from polishing it up.
So it's very important for you to have all the papers together, all the photographs, all the CDs, whatever evidence is there against you and for you. You have to have everything together before you start drafting.
And the worst mistake you can make is to start drafting before you're clear what it is that you're going to argue. Because
you cannot start drafting and then tell the client, all right, you bring the papers later on. No, everything has to be incorporated because the draft has to be made while keeping evidence in mind. What are you going to lead in evidence?
Ultimately, this all leads into the oral arguments that you're going to make in court.
Drafting of pleadings in different courts has different challenges.
There's complete difference when you're drafting on the original side, that is when you're filing a fresh suit, whereas when you're filing, say, appellate Supreme Court appeal or even a High Court writ or a High Court appeal.
Pleadings before civil courts and criminal courts should always be confined to the bare minimum, should only state the relevant facts which are necessary to prove your case, to show that you have a cause of action, and nothing further. Because the more you say insofar as pleadings before civil courts and criminal courts are concerned, the more you increase your burden to proving that when the actual trial starts.
You will realize if a matter goes to trial that it's not the other side's documents that come back to haunt you during the stage of cross-examination. It's your own submissions, it's your own pleadings that really bite you in your derriere for one good reason. You would have made statements and submissions in the heat of the moment because you're putting together a document without actually understanding its implications if that particular statement were to be tested on the anvils of evidence at the stage of cross-examination. So as far as a draft is concerned, even if it is a draft that is put at short notice, keep it slightly open-ended, keep it strictly to the point. Submissions which don't add value to the facts in issue and which don't really help you advance your case need not be made.
And it's very important when you're drafting a plain that you do not miss out on any relevant fact which is important for you to get the eventual relief. And therefore, before drafting, you must understand what are the specific facts for those kind of suits which must be pleaded in the suit, because it can be fatal to your suit right to up till the Supreme Court if you don't plead it in the plain. Now, insofar as the Supreme Court drafting is concerned, that is where you are mostly dealing, it's mostly appellate jurisdiction, you are always challenging an impugned order. And the key there to remember is that if it's 136 SLP, if it's a special leave petition, it is not incumbent on the Supreme Court to correct every legal error. So it's not just sufficient to point out to how the order of the High Court is incorrect. Also, you have to point out why it's important enough for the Supreme Court to take up this issue and hear it.
Your most important points and propositions have to be summarized in the synopsis and thereafter explained and reiterated in the memo of petition. And what you should focus on is explaining in the synopsis how the findings by the High Court are incorrect according to you, and why the judges should therefore interfere in the matter and grant you some relief.
But what the judges will definitely have read on the first day when they're hearing a petition is the synopsis and list of dates. And the synopsis, it should be 3 or 4 pages, and it has to really point out in very, very concise form why the Supreme Court should definitely hear this matter, both on facts and on law.
Ideally, of course, pleadings should be brief and pleadings should not contain any law. That was the first principle that we were taught in law school. However, the situation has now changed when it comes to writ petitions and special leave petitions in particular, because you have to explain your entire case, not just the facts. So therefore, it is now necessary, in fact, to focus not just on the facts, but also to incorporate the legal propositions and the cases in support.
And in Supreme Court petitions, you will quote law a lot more liberally, because most often than not, you will be saying that there is a serious legal error which has been committed by the High Court below.
Too often drafts are repetitive, vague, and they don't really come to the point.
There is a reason why it's not called writing, there is a reason it's called drafting. It's much more chiseled, it's much more to the point.
I think it's really important to be concise, to state up front so it's clear to the judge as to what it is that you're filing, under what provision, and what relief are you seeking, and very briefly for what reasons, just in 2 or 3 paragraphs.
The current movement is towards clear communication and effective communication.
I think avoid using archaic jargon, which is unfortunately still in use in a lot of drafts. And at the other end, sometimes as corporate drafting, there can be too many defined terms which, are difficult for courts, especially if you use defined terms in prayer clauses. So sort of keep it simple, but at the same time, be concise and be to the point.